Hear ye, hear ye. Now, the Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give attention to the court is now sitting. God save the United States, the State of Michigan, and this honorable court. Welcome to our May arguments. Before I begin, I'd like to recognize Judge Maeda from Japan, who's visiting with us today. Good morning. Welcome. For those of you who are not frequent flyers, I'd just like to go through the catechism I give every time. We have read your briefs. We don't need a regurgitation of what's in your briefs. We want you to get to what you believe to be the outcome determinative issues in your opening remarks. I hate technology, especially loud technology.
It's court authorized, so what can I say?
To get to the outcome determinative issues in your opening remarks, we give you those remarks question-free. All of the cases today are MOAs, so the sides have 15 minutes each, and the first two of which are question-free. So we'll call the first case, People versus Feeley.
Good morning. May it please the court. William Vailliencourt, prosecuting attorney from Livingston County, appearing on behalf of the people. I'd like to reserve 2 minutes of my time for rebuttal.
You have to manage that yourself.
And I'll keep my own time. Thank you. This is a question of statutory interpretation. The resisting and obstructing statute protects police officers. The issue here, who is a police officer? The law is consistent. Because police officer is not a defined term in this statute, it should be defined according to its common meaning and usage. The test should be, is the person authorized to perform law enforcement type duties, and are they purporting to do so? Which is precisely the test set out by Judge Sawyer in his dissent. The fundamental flaw in the Court of Appeals opinion is its premise that a reserve police officer is not a police officer. But to say that they are not means that you have some definition you are applying. Yet the Court of Appeals definition is unknown and undescribed. So I'm asking you to adopt Judge Sawyer's dissent, and I'll waive the balance of my free fire zone.
Counsel, good morning, and welcome to the court. Counsel, the legislature was quite explicit in what it listed as a subset. How to address, a concern that I might have as to who would not be included as a police officer? I know that the legislature was, pretty clear in saying that this is not limited to. But I guess if you could help me on this, help me to understand under the subset who you would not determine to then ultimately be authorized as a police officer under the subset that we're dealing with.
Well, that's where I think you use the plain language meaning of a police officer, somebody that's carrying out law enforcement type duties, and they're purporting to do so. And you look at, I think we all know what a police officer is, somebody that's trained, they're in uniform, they have a badge, they have a gun, and they're engaged in duties to enforce the law. You look at the other part of the statute says a police officer.
Well, Counsel, let me just stop you just because I just want to pursue this with you a little bit. Would an auxiliary officer, many police departments have auxiliary people, which are citizens that kind of participate within the police department. Would an auxiliary officer be considered like a police officer or a cadet? Help me to understand if you're looking for a definition, how would I define it and how would I limit it?
Well, a reserve officer is simply a subset of the general class of police officers. You look to see, are they trained? Are they carrying out law enforcement duties? In this case, there is nothing in the statute that carves out or draws out any separate exceptions for subsets of police officers. It simply uses the definition reserve police officers. So it includes full-time officers, part-time officers, probationary officers. It's any person that is authorized to carry out law enforcement duties. And when you look at the remainder of the section talking about adding to the definition, said police officers.
Well, could a TSA agent be then under your definition? Could you have like a TSA agent, or could they serve in this context?
Well, a TSA agent, I mean, there are separate provisions that cover conservation or cover federal officers. So there would be a question as to whether or not they're a peace officer of a duly authorized police agency of the United States. That would be something you would have to look at. But under the test of are they provided with law enforcement authority, law enforcement type authority, and are they purporting to do so, I think an argument could be made that yes, a TSA officer could fall within the class. But the question here involving reserves, I think, is not even a close case.
Counsel, what is the scope of Officer Roberts' duties and his authority, I guess, when he's in the company of a full-time officer? And is there an authoritative source that makes that plain for me? Is there an ordinance or something that says, here's what a reserve officer's duties are and scope of authority is?
Well, the scope of their authority is defined by the police department. Many police departments have reserve officers. In fact, I was a reserve police officer for 13 years, and each department has their own limits. Some give reserves very limited authority. Others, like Brighton, when you're working with an officer, you have the same authority as a full-time police officer. You have the authority.
Is that written down somewhere in this particular case? I take your word for it that they define them, each department defines it however they like, but is there some authoritative source with respect to Officer Roberts that I could?
Well, it would be set down that in the Brighton City Code authorizes the creation of a police department, the appointment of officers, and actually this court in Smith versus City Commission of Flint recognized that there is no doubt that control of a city police department is a function of local municipal government. So it's left to the local governments to decide who they may choose to empower.
Isn't this very question one which the Court of Appeals didn't decide? There were two issues. One, was this individual a person, as defined by the Act, a police officer? And the second question is, was he acting within, what is the term, his duties?
Yeah, I think
Weren't there two questions that were before the lower courts? And
No.
the Court of Appeals never answered the second one.
Well, I don't think there was any question that the officer was acting within the scope of his authority. The question was, given the authority that he had, did he fall within the definition?
Do we have some record about that allows us to determine, as a matter of law, he was acting within his duties as a police officer?
Well, ultimately, it's going to be a question of fact, but the question is, what is the law? So
This is a bind-over decision.
This is a bind-over
And
decision.
there were these two questions that the statute required, two elements.
Yes.
Right? And all of the lower courts made the determination that the bind-over was not appropriate based on the fact that they determined he wasn't a police officer. Isn't that right?
Yes, as a matter of law, that he was not a police officer.
So the second question really hasn't been addressed in the lower courts yet.
Well, I don't think there was ever any question about whether he was acting as a police officer. I think that's clear in the record. Obviously, that's a matter that that can be tried in the lower courts. But given the fact that he was in uniform, on duty, carrying out authority, his duties, I think it's a pretty easy fact question as to whether or not he was purporting to carry out his duties as a reserve officer.
He doesn't have the power, a reserve officer doesn't have the power to effectuate an arrest by themselves, do they?
Yeah, as long as they're working in conjunction with a full-time officer, yes, they do.
What does that mean, working in conjunction with?
Meaning, police officers, they always have radios, so they're in contact with each other that way. So as long as they're working, in conjunction under the direction of a full-time officer, then they have the same authority to do so. Whether they're either in the same car, in the same area, it's frequent where reserve officers may not be. They're not going to be joined at the hip. They'll be, different areas of a stadium or something. But as long as they're in contact with a full-time officer, then they're working under the direction of a full-time police officer.
But Counsel, the legislature gave a pretty exhaustive list, and it didn't include reserve officer as a factor in that list. And You indicated that you were a reserve officer at one time, so we've had reserve officers for quite a long period of time. How should I read into that? That, like, the legislature was obviously aware that we had reserve officers. They've been around for quite a long period of time, but yet it wasn't encompassed in a list that included literally every other definition you could possibly have of an officer. How would you respond to that? How would you help me with that?
Well, because there's no distinction really between a reserve officer and a full-time police officer. The defendant argues that essentially what the R&O statute does is it incorporates the MCOL's requirements. But if you look at the statute, the legislature clearly knows how to incorporate definitions from other statutes. There's a laundry list of persons that are covered. For example, it includes emergency medical service personnel, as described in another statute. Individual engaged in search and rescue, as defined in another statute. Serious impairment is a defined term, as defined in another statute. Yet in this statute, they did not choose to import the requirements or the definitions from the MCOL statute into the definition of a police officer.
And doesn't the MCO statute say in its definition sections, as used in this act?
Precisely.
Just like the vehicle code says, for the purposes of this act.
Exactly. And that's one of the flaws in the defendant's argument, is trying to say, well, let's look at MCOLs and these other statutes. The legislature has already said that those definitions specifically apply to those statutes and not any other statutes. And I think that's consistent or with what this court has ruled, last term in People versus Mazur, that as used in this act means precisely that. And then also in 2012, this court in Grimes versus Department of Transportation said that you can't use the definitions from the vehicle code to define what the highway exception is in governmental immunity, because definitions that are set forth in a specific statute are limited to that specific statute.
But to say that those alternative definitions are not binding, which I think the language in those acts suggests is in fact the case, doesn't mean that they can't nonetheless be persuasive.
Well, but here, because you're using an undefined term, you have to look to what the plain language meaning is for a police officer. And I'd suggest that using, a functional approach, you've got somebody that's authorized and trained. They look exactly like a full-time police officer. They're in uniform. They're indistinguishable from a full-time officer. You have a reserve and a full-time officer. There is no distinction between them while they're working.
Can I get back to this? So I think the Chief Justice was, when he built on my question, built it in a different direction than I meant it. I think you understood me in the way I did mean it. No offense.
None taken.
Because I wasn't talking about whether there was a record with respect to the second element of the charge. I think that can be handled on remand, and I'm just asking for the purpose of understanding, whether Officer Roberts is the equivalent of a police officer, which there seems to be a lot of good reason to believe he is. Does the police department where Officer Roberts works define his duties and authority, and does it say they're the same as any police officer?
It's defined by the chief of police
Where? In writing, or just he tells them?
In departmental policies. Departmental policies for the city of Brighton.
Policy somewhere?
Says yes. I mean, the city has a policy. Yes.
Can I find it somewhere? Or?
No, departmental policies I don't believe are available online. I mean,
okay.
I've got a copy, but I mean, the department, every police department manages its own affairs and defines how reserves are going to be utilized.
I take your word for it. It just seems like it might be helpful in understanding why, at least with respect to Officer Roberts, he's no different than any other police officer if the policy says your duties and authorities are exactly the same as the police officer. So I might have liked to have.
And in this case, Officer Roberts testified about
Okay.
that. He testified what his authority was, which is really no different than in any other resisting and obstructing prosecution. The arresting officer will testify and say, I'm a police officer for the city of Brighton. And that establishes the factual predicate for that particular element. Maybe somebody chooses to contest it.
Yeah.
There'll be a factual question. But in this case, Officer Roberts testified extensively about his qualifications and that he's been authorized by the city of Brighton.
But counsel, help me to understand the boundary. That's what I'm trying to grapple with right now. help me to understand where you would put a boundary to say that, you know, who is a police officer and who is not. That's just what my concern is right now, is what the boundary is. So let me just give you a hypothetical. Let's just say you have a state building and the state employs a private security force to kind of protect that building. Would a private security force who is hired to protect a state building be able to constitute the position of an officer and do arrests and do things of that nature?
No, because they're a private entity. They've not been endowed with any governmental authority. They're simply acting by virtue of a contract. They're a private security guard, so they're different. In this case, a reserve is given specific authority to carry out law enforcement functions.
But I get the issue with the reserve. My concern is the definition in terms of who would not, where do we draw a line to say, what can you point to me? Help me to understand what I can point to say that, okay, here's a clear definition of who would not be included in terms of this statute.
I mean, the definition really is, well, who is, and that's what I borrowed from McCrae, the test. You look to see who is authorized. Are they authorized as a state actor? Are they given authority to enforce the law, and are they purporting to do so? And I see my time is up. I'll be happy to answer any more of your questions. But
Let me just follow up on one thing you said about departmental policies. That the chief, you seem to imply the chief could confer authority or power on a reserve officer, and that seems a little odd to me. Is it your position that the chief could confer this power even if state law does not?
well, if the state law were to preempt it and say you can't do something, but local governments have the constitutional authority to run their own police departments. That's what this court held in Smith versus City of Flint. You know, that they have the authority to run it unless there's some statutory proscription. And there is no statutory prescription here for reserves.
So if the chief of police wanted to say, and again, using your earlier description, that, our budget is tight, and so what we're gonna do is send out 2 reserve officers. They'll be in radio contact with the dispatcher, but we'll just send them out to respond to calls, and they can do all the things that police officers do. According to your theory, that would be valid?
Well, no, they'd have to be working in conjunction with a full-time police officer.
Well, you said conjunction. So
In
all right,
conjunction
maybe
with.
maybe dispatch is not a sworn
Dispatcher
office.
won't count. Theoretically, yes, it could happen, but obviously, there's liability issues for police departments. They want to make sure that they're not just sending people out without the appropriate.
Why do you need to go there to win in this case? There's a provision in the statute that we're looking at that includes a firefighter, which firefighters obviously don't have the authority to effectuate arrests. So,
Right.
do you need to prove to us that reserve officers, in quote unquote, in conjunction with full-time officers, have the power to effectuate arrests to win today?
Well, because we're talking about what is a police officer, and that's a traditional police function, is enforcing the law. But no, the statute is quite broad. It even includes search and rescue operations, which quite frankly is just a group of people. If a police officer were to come in and say, we're looking for a lost child, would you all like to help look? We're all going to be covered by that provision of the resisting and obstructing statute. And there's, constables, they're not certified. Deputy sheriffs, technically not all of them are certified under MCOLS. So you've got a statute that's very broad and encompassing in protecting people engaged in these type of duties. And I think a reserve is simply a police officer, in this case, is in what Officer Roberts was doing.
Thank
So
you.
I have used my time. Thank you
Since
very
you're
much.
not coming back, let me just ask. As I understand your plain language argument, a reserve police officer, reserve being an adjective, it modifies police officer. It's a simple subset. Therefore, all reserve police officers are police officers, and that's the end of it.
Yes.
What about these communities that if you pay a little bit of money to whatever fund, FOP, whatever it is, you become a reserve police officer and they send you a badge?
I think there's going to be a fact question there, is whether that's a sham. Are they really authorized? Have they been granted? It's one thing, I guess, for them to pass out a badge saying thank you very much, versus giving them a uniform, a gun, and a badge, and putting them in a police car with a full-time officer and a radio and going out and working a shift. Those are 2 different things, and that's a fact question that in that kind of a circumstance could easily be fleshed out in the trial court.
Thank you.
Thank you.
Good morning, may it please the court. I'm Brian Morley on behalf of appellee Ryan Feeley. I have two primary points that I'd like to make by way of opening. We're dealing with a state statute here. A city police chief cannot, by his own motion, decide that my officers or my reserve officers' actions are then covered by state statute. There is no way to make a reserve officer a police officer. Reserve officers are not trained. It's happenstance in this matter that this officer went to a police academy. He's not trained. The Michigan Commission on Law Enforcement Standards has no jurisdiction over him. It is no different, and I don't want to be trite, but it is no different than allowing a person who hasn't gone to law school to stand up here and argue before the court. You couldn't do it, because if I came up here and I acted disrespectfully, the state bar has no jurisdiction over me. I don't have any ethical rules. I don't have any licensing. It's the exact same issue with reserve officers, because there is no distinction between a reserve officer who a department might have a little bit more control of, or an Oakley example where if you pay a couple dollars, you get. There is no distinction. There is no state statute addressing reserve police officers. The second point I would like to make respectfully to this court is we shouldn't be here addressing this issue. The legislature is addressing this issue. The Michigan Commission on Law Enforcement Standards, whether we determine that the MCOLS Act should be read in conjunction with this statute, has legislation pending that has been pending for a while that specifically excludes reserve officers from its jurisdiction. More importantly, less than 2 months after the Court of Appeals decision in this matter, the state senator from Livingston County presented a bill to the legislature, Senate Bill 668, which is pending but has not been taken up, that specifically is seeking to include reserve police officers into 750.81D.
Counsel,
Yes, sir.
section B8 of this statute includes firefighter. I don't understand your argument that this statute cannot encompass a reserve officer if the legislature included someone who clearly is not a police officer.
I think the distinction, Your Honor, is the law enforcement portion of it is clear. I cannot stand before the court and say a firefighter is a law enforcement officer. He's not. It's meant to protect firefighters. They are a subsection within those persons, and I believe that's why subsection B says person. The law enforcement definitions are clear, and if you look to subsection 1, the motor carrier officer or capital security officer, both of those are given statutory state authority, and interestingly, the capital security officers are specifically in that statute given the authority to make a warrantless arrest for assault and battery. It's specifically added into that statute.
Into which one?
The capital security officers.
Yes.
It's cited. I'm sorry.
Yeah, go ahead.
It's cited within. Off the top of my head, I don't have the statute. I apologize, but it specifically says a capital security officer may make a warrantless arrest for a violation of 750.81, which is assault and battery. That's extremely important because a reserve officer cannot make a warrantless arrest, as referenced in my brief. A peace officer has to be an MCOL certified officer in order to make a warrantless arrest.
No,
So
let me just say, I don't understand the reliance on MCOLs. That is a certifying statute, correct?
yes, sir.
If certain sheriffs are not certified under MCOL, correct?
Deputies are. Everybody since 77 has to be certified.
Including the elected sheriff?
To my knowledge, yes.
Right. So you're saying that MCOLs rather, is the defining statute that if you're not certified, you cannot be within the list of law officers?
I don't think that's what I'm saying. I don't think we get to MCOLs. I think we say.
I don't understand how we use MCOLs, since the definitions in MCOLs by explicit statement only refer to MCOL.
And I don't think we get there. I'm saying nowhere does this 750.81D say reserve police officer, case closed. I'm saying that if If it doesn't, legislature handle it, case closed. If, however,
Except this, it isn't listed explicitly, except it says, including but not limited to.
I understand that, but the limitation.
That's not in statutory construction parlance, that's not a term of limitation but expansion,
I
correct?
agree. But the distinction there is that the including but not limited to examples, which can and should be relied upon, are persons whom are given state authority to perform law enforcement action. There is no state authority for a reserve officer. I'm saying MCOS is the best example because MCOS deals with police. So let's look at the agency that deals and their statutes that deal with the police. But I'm primarily saying, Your Honor, we don't get there.
What's your definition of police officer?
Certified officer. For state purposes, there are.
Certified officer for state purposes?
Yes, yes, ma'am, I apologize. It's similar to a lawyer.
You need to stand behind.
I apologize.
Secretary.
I can.
I didn't feel threatened. I was fine.
No,
For the microphone.
but the microphone was without input.
Can't be a good thing. It's akin, and I don't want to be trite, Your Honor, but it's akin to going to law school but not getting licensed. I can pretend like I'm a lawyer. I can go with another lawyer and see what court is like, but I can't do anything. I can't do anything under state authority. It's the exact same thing. There is no state authority for a reserve police officers. They are different in every municipality, and to say then that the state statute incorporates what a local chief wants to allow his officers to do is improper, and if we get into the lenity issues, it's not appropriate to allow that to happen because a person is entitled to know the law.
Yeah, but the rule of lenity is designed for notice to the defendant, right? And so if I were your client and I'm looking at these two officers, one has the certification under state law, the other one doesn't, but to me, the defendant, they look the same, they both have a badge, they both have a gun. And I know that I can't resist arrest of a police officer. I'm just wondering how a notice argument works for your client.
And candidly, I'm not sure it does. The lenity argument needs to be contemplated by the court, I believe, but I think you're absolutely right, Your Honor. I think it's who are you to decide whether this uniform is a reserve uniform or a regular uniform.
Right, because otherwise I'd say, oh, could you show me your certification? If so, if you don't have one, then I'm gonna resist
I'm
your
outta here.
arrest or assault you.
Or do I just take the chance and punch you and hope that you're a
And
reserve
hope.
officer?
Yeah.
I think that's a fair, and that's why lenity is not a strong argument. But when we get into the court system, not in the field, if you will, but when we get into the court system, the issue is then, all right, here are my actions. Are these actions within the state statute? Interestingly, Your Honor, and it hasn't been referenced, the Brighton City Code, which makes resisting and obstructing a misdemeanor, says any member of a police department. So under the Brighton City ordinance, they got them, and it's a misdemeanor. But under the state statute as written,
Well, wait a minute, the statute says any person, any individual who batters or resists, obstructs, a person who the individual knows or has reason to know is performing his duties. A uniformed officer would signal to me that this is somebody who I ought not batter or resist arrest, doesn't it?
and we all stand in court and say the same thing. I'm not going to stand in front of the court and say, nah, take your chances and try to fight with
Well,
the
but
cop."
isn't that what your argument amounts to?
Not at all. Not at all. My argument is that the statute as drafted plainly says you cannot be charged under this statute. Does it make his actions wrong? Yes.
Okay, I think I understand.
As I understand your brief, you're both claiming plain language, but you say you went under a plain language analysis, correct?
Yes, sir.
And when we do a plain language analysis, we're to take the words, apply rules of grammar, and try to discern what is meant by those words. The Attorney General filed an amicus brief that I thought raised a good point, that the word reserve is an adjective, and adjectives modify nouns. They don't nullify nouns. And your interpretation here is that by putting reserve in front of the police officer, the legislature meant to exclude. By identifying this officer as a reserve police officer, they're not a police officer at all.
Well, I don't think they are. They're not in the state of Michigan.
But
They're
if
not.
we're applying plain language and we see reserve officer, wouldn't that adjective?
I'm not going to be competent to get into a grammatical argument, but I would argue that the reserve is.
I'm sorry, what did you just say?
I wouldn't be competent enough to get into too deep of a grammatical argument, but I could say that I believe.
What are we doing here?
I'm trying my hardest, Your Honor. I believe that the word.
Let me put it in a different term. Is something that's identified as a red car any less of a car just because it's identified as red?
No.
So why, when we identify a reserve police officer, are they any less of a police officer because they're identified as reserve?
Why would we call them a reserve officer? Why would I ask?
Because they aren't there working every day. It's not their everyday main function. But when they are there, they are under the McRae standards. They're doing all the things. They're uniformed. They're assigned to a car. They're issued a pistol. They're responding to a call. All these things suggest to me this is a police officer.
In this department. Other departments are different. Other departments don't let them carry guns.
Well,
it's different
your
everywhere.
opposing counsel pointed out that might be a case where there's a fact question whether it is a sham or a fraud to call him a reserve officer.
But a reserve officer has no state authority. Your red car is still a car, can still do whatever it needs to do. A reserve officer has no inherent authority or state authority and can do nothing on its own. It has no battery, without sounding trite. But a reserve officer can do.
Tell me where I should look in the statute to conclude that the equivalent of certification attaches to police officer in the language of the statute.
I can't. I think that's why we're here. I think.
Well, but that's my concern. If the statute seemed to suggest that you had to be a certified by the state to be a police officer, I could follow your argument. But looking at the language, it says a police officer of this state or a political subdivision of this state. So I'm trying to find where I go to add the additional requirement that they must be certified police officers of the state or a political subdivision.
I don't know that they need to be certified. I believe that they need state authority, as referenced by motor carrier officers and capital
security officers. But it says a police officer not only of the state, but it continues, or of a political subdivision of the state.
Vested with state authority is the inference.
That's where I'm now, when you start adding vested with state authority, that's the part I need you to help me locate in the actual language of the statute.
Well, of course I can't, and that's exactly my point.
Don't you lose then?
Not at all. I believe that this of this state or a political subdivision means a police officer according to the common terms, not a differentiated reserve police officer, and not somebody who has what the chief may be accepting money for, maybe deciding is going to do this, or that. It's a local municipality issue, in my opinion, versus a state authority issue.
Okay. Counsel?
Yes, sir.
Whereas I think both the MCOL statute and the vehicle code are, contain definitions that are not necessarily relevant for this case, both because those statutes are not in pari materia and they limit their definitions to the scope of those statutes exclusively. You do have a statute that's in pari materia, which is, of course, the Michigan Penal Code, which is the very same statute. And the Penal Code contains a provision, which is obviously in pari materia for those reasons, MCL 28.421, which says that a peace officer includes a reserve peace officer. Is that not at least some positive indication that a reserve officer is covered by this statute?
Again, to the extent that the court feels that there needs to be interpretation, there is not a statute that helps us in pari materia perfectly. That's close, the penal code. I would argue that MCOS is closer because they're both looking to enforce.
If we had a perfect statute, probably we wouldn't be focusing on this case today.
Exactly.
But we have an imperfect statute, but a not too imperfect statute, don't we?
I agree. It needs fine tuning by the legislature.
What's wrong with the argument or the statutory reference that Justice Markman?
Nothing. And that's just what I just said. It's not exactly on point.
Well, it's at least in the same statute.
As is MCOS. MCOS points us in the right direction. The vehicle code arguably points us in the right direction. Fortunately, we have.
This is the same, the provision that Justice Markman mentioned is the same statute as this statute that precludes resisting and,
Within the penal code.
yeah.
Yes. Which would suggest to me that if it were within the penal code, it could have been included in the definition section within 750.81D.
Any other questions?
Thank you, Your Honor.
The case is submitted.